Hi, I'm Brian with Hanning Law Limited, attorney for businesses and creatives. Today I'm back with the next video in my series. We're going to be going from the application through to the end of the process as a roadmap for some of the next episodes in this series, and just because understanding what the process generally is a useful thing. Starting before the application, the first step of the process is that search. We've talked about the search before and how you want to know not just if there's somebody with your same name, but if there's anybody with similar names or close enough names. And so, or even close enough logos. So we're really going to want to do a search there and be confident with our application before we get ready for it, filing. Then we put together the application with the information we discussed in this very last video, and we then file it. Once the application is filed, it has to be examined. Now, before 2019, we were really looking at about 3 months to hit the examiner's desk. Currently, as a time of recording, it's pretty close to that 6-month mark. There's some information that suggests they might be able to get that shortened, but there's also an increase in trademark applications, so ballpark at 6 months and keep that expectation for the foreseeable future, I would say. When the examiner gets it, they move through the application pretty quickly. This is, it's their day job. They know how to review an application. And there's going to be one of 3 results. The first is that it's going to go through without any problem. The end, you get a notice for the next step. Sometimes you get what's called what I call a technical office action. And other times you're going to get a substantive office action. Both of those are issues with the application itself, and it's either a fix or an argument to be made. We'll talk specifically about the office action in the future. Just keep in mind that a technical can typically be resolved in days or weeks, and we're leaning closer to the shorter of those concepts. But if it's a more substantive issue, if there's a refusal on a significant ground, you're potentially going to be getting a period to respond. They're going to give you that period, and it's going to be at most 6 months. With the 2020 Trademark Modernization Act, there is the ability for that office action to be a shorter time frame. But we're definitely looking at a more month-long type of process, or months-long type of process with the substantive office action. Once it gets approved, either after we make any office action adjustments, arguments, etc., or it was just approved at the beginning, we will go into the publication phase. Publication you're generally given a notice of that. So it's, hey, we will publish this in the Trademark Gazette on such and such day. It's generally a couple of weeks out, about a month-ish. Once it's in that, in the Gazette, once it's been published, anyone with a trademark that feels like they would be injured by the registration of your application can object and can intervene in the process. This isn't necessarily very common, but when it does happen, it can be a fairly significant investment as well. But it's a 30-day publication period, so whoever is doing this either has to already know that you exist and be prepared, or they have to find you, make the argument, and publish that argument within those 30 days. It happens, it's not exactly going to happen on every single application. It happens on occasion. Once the application period is completed, it will then be moved to the registration division of the USPTO. And the registration division is going to finalize the certificate. They're going to get the data, they're going to get the number, and they're going to mail a physical copy to you or your attorney or other representative. And that can take up to a couple of months. Again, it depends on how many applications are there at the time. Sometimes it's weeks, sometimes it's closer to a month and a half. But at that point, you have the registration number and you have a trademark, and you're looking at post-registration maintenance in the future, but primarily the process has been completed. So with that, next time we are going to talk about office actions. Talk to you next time.